appeal partner in the matter of staff cooperation with
Good morning. It's very nice to see everyone gathered together, and let's press on.
May I please your ladyship, very brief recap of where we were before we adjourned. On the first day, I submitted that it would not be possible for this court to interpret the words in subclause C, the actual or estimated value of the goods, as meaning anything other than value on the same terms as the original contract, without inconsistency with Bungi and Viterra. The reasoning in Bungi and Viterra was partly based on common law and Sale of Goods Act principles, and I was addressing the cases relied upon by Sharp in relation to the common law and Sale of Goods Act principles to examine whether they did actually cast any doubt on the proposition that I applied from Bungi and Viterra. I had addressed Macklin, Barrow and Arnold and Muller, McLean and Leslie Anderson, and I was about to turn when we adjourned to Arya and Lawrence Costoris, which is at page 61 of the authority's manual.
Thank you.
Maybe recall that this was a somewhat involved sale of goods case about various kinds of fabric. For present purposes, we are concerned only with the claim in relation to a parcel which is known as the Isari parcel, and we can pick up what the claim was in relation to that at page 62 of the bundle, internal page 64 of the law report. In the right-hand column, just above the final paragraph, the last 3 lines of the preceding paragraph, in respect of the Isari parcels, his claim was in respect of breach of warranty of quality.
Yes.
My learned friend took you to a passage in the judgment of Lord Justice Ditlock, which is on page 69 of the bundle.
Yes, he did.
Internal page 71, left-hand column, and he showed you the part that was is boxed in red. I would accept that where to the knowledge, etc., as a proposition as to the relevant market for sales on CIF and FOB terms. But what he didn't show you was the preceding paragraph, which we've highlighted in green, with respect to the consignment of Dimity and Voile, which the plaintiff claims that he sold on to Isari. The plaintiff accepted these goods. His only claim is for damages for breach of warranty of quality. So what Lord Justice Ditlock says in the passage my learned friend relied upon is that the measure of damages for breach of warranty of quality is based on the values of the goods on the market on arrival there. It doesn't say anything about what the measure of damages is for non-acceptance. And so in my submission, this authority doesn't shed any light on the question we're concerned with. And this is relevant to the next authority, because this authority is cited in the Selder, which is at page 121 of the authority's bundle.
Yes.
You may recall that the Selder is a GAFTA default clause case, and my learned friend relied upon it for 2 propositions, but he accepted expressly that the passages he relied upon were obiter, or at least were not ratio. The 2 propositions that he relies upon the Selder for are firstly that the actual or estimated value of the goods in subclause C falls to be determined on the market at the destination, if there is one, and he sets that out in paragraph 36 of his skeleton. And his second proposition is that the second valuation in subclause, second valuation option in subclause C, actual or estimated value, the one we're concerned with, simply replicates the standard measure of damages in section 50, subsection 3 of the Sale of Goods Act. And he says that at paragraph 37 of his skeleton. Just to briefly recap what the SELDA was all about, it was a claim for non-acceptance under a C&F contract, a sale C&F Turkey. There was no claim for damages under the equivalent of subclause C because the charter party was cancelled by the sellers before the goods were even loaded. The only claim that the sellers made in those circumstances was for the cost of cancelling their charter party as a result of the buyer's default. There was a question in the case whether there was a market C&F Turkey, but that only arose because of the way that the buyers put their case. The buyers said that the sellers couldn't recover losses outside of subclause C unless they first showed that there was no available market for the goods. And we can see that if we pick it up on page 124 of the bundle. Internal page 732 in the right-hand column. My learned friend showed you the passage at the top, beginning, Miss Ambrose stressed that there was no express finding by the arbitrator that there was no available market. And the paragraph goes on, the market in question for present purposes being Turkey, this being a C&F contract. See ARIA. And citation from the passage of Justice Diplock that we've just looked at. My learned friend relies on that. The first point to make about that is it's not entirely clear there whether Lord Justice Hurst is simply quoting the submission that was being made by Miss Ambrose, or whether he is actually accepting that ARIA is the relevant test. But if he is accepting that ARIA is the relevant test, then in my submission that was based on a mistaken understanding of what that passage was about, because that passage was about breach of warranty of quality and not non-acceptance. In any event, the only reason why the question was being asked was because of Miss Ambrose's submission halfway down the page. So below the red sideline part, Miss Ambrose submitted that section 50, subsection 3 is the government governing principle, and it's incumbent on the buyer positively to establish that there is no available market before he can invoke the more general rule in section 50, subsection 2. Lord Justice Hurst rejects that, saying, to my mind, this is putting the cart before the horse, since subsection 2 lays down the general rule and subsection 3 is expressed to apply prima facie. And in my submission, that is correct, and that is the way that the section is understood to work in subsequent authorities as well. There's a general principle in subsection 2, and subsection 3 is simply an example of it. It follows that everything he was saying about whether the arbitrators found that there was an available market was obiter. But if he was saying that the tribunal found that there was no market for tapioca sold C&F Turkey, in my submission, what he really meant by that was that there was no market to sell on C&F terms Turkey in circumstances where the import of tapioca was prohibited.
It wouldn't have made any difference on the facts of this case.
No, quite. And that was what the sellers themselves had submitted. So if one goes back one page to 123, the left-hand column of internal page 731 should be around where the upper hole punch would be. Going through the facts, nothing was heard on January the 11th, etc. Sellers said they received an ETA from the vessel for January 19th and explained the risk to load this non-EC tapioca is too big, as currently there are internationally no buyers. So what they were talking about was the international market for sale of C&F. course, logically, if you ban imports, then locally there is likely to be a market, bigger market. That's usually why you do ban imports. But in any event, the issue that we're concerned with of the terms of a substitute sale for the purposes of section 50, subsection 3, wasn't before the court, so this authority doesn't help. And as to the second proposition that my learned friend relies on this case for, that section 50, subsection 3 is replicated in the default clause, well, that is consistent with our case, that section 50, subsection 3 refers to a current or market price on the same terms as the original contract. So there's nothing between us on that. That brings me to two decisions which are on forms of the default clause and which do touch on the issue that we're concerned with, and that is the Eurometal and the caloric. Beginning first with the Eurometal, which is at page 90 in the authority file. The default clause in that case was slightly different, but not in a way that makes a material difference in my submission.
It had a cap.
Sorry?
It had a cap, essentially.
Yes, it was shall not exceed the difference between the contract and the market price rather than shall be based on, etc. The facts, just to recap the facts, this was a contract for a sale of Spanish barley, CIF 1 safe port, West Coast, Italy. The goods were shipped and they arrived at La Spezia, so La Spezia had actually been nominated as the port, West Coast Italy port. The buyers wrongfully rejected the documents and the sellers declared them to be in default. Default was declared almost a month after the vessel had arrived at La Spezia, during which period demurrage had accrued. And we can see those facts are set out on page 93, particularly by little letter C and little letter, or between little letter C and little letter D. The case was partly considered with liability, which we are not concerned with. We are concerned with damages, which begins on page 98 of the bundle. And the first important point to note is that under the original contract, demurrage was for the seller's account. So in other words, there wasn't any term of the sale contract which meant that the sellers could pass on liability for discharge port demurrage to the buyers. And we can pick that up from page 99 by letter D. If the sellers had remained liable for demurrage, could they have recovered the demurrage as part of their loss on resale? What that tells us is that, putting aside the arrangements which were made, the sellers were liable for demurrage, so they didn't have a right to recover it from their buyers under the sale contract. And we also can see that from the discussion of this case in the caloric, which Mr. Justice Lloyd decided shortly afterwards, page 103 of the bundle. Internal page 678 by the right hand, in the right hand column, right at the top, so top right of page 103 of the bundle, I was referred to an earlier decision of my own in the Eurometal, and it goes on a little bit. The sellers resold the goods at $116 per tonne to SIAT. There was a provision in the resale contract that SIAT should pay the demurrage, which would otherwise have fallen on the sellers. So again, that shows that under their original sale contract, there was no right to pass on the demurrage liability.
That would be relatively unusual, wouldn't it? I mean, typically buyers will have to bear demurrage.
Nowadays, I don't know whether that was the norm at the time these cases were decided. But yes, it is now standard practice for there to be some sort of shifting of the demurrage liability onto the buyers, and we see that in the caloric, because that was the case where that was the case.
Yes.
But the point about the demurrage is that this is what gives rise to the problem in this case that Mr. Justice Lloyd had to deal with, because the sellers had put their case on subclause A, so they were relying on their resale of the goods to SIAT, which they did at a headline price of $114 per metric ton CIF free out La Spezia. But, as we can see from the passage at page 98, letters F to H, we've sidelined,
98?
Page 98 of the bundle, internal page 541 of the report.
Yes.
There should be a passage sideline beginning by the letter F. As already mentioned, the sellers declared the buyers in default, etc. What happened was there was a resale to SIAT at $114 per metric tons, free out La Spezia, but that had various terms that were not in the original contract. Firstly, it had an option to take delivery at Venice for $2 per metric ton, which SIAT exercised. Secondly, SIAT undertook liability for accrued and future demurrage, which in the end amounted to $63,838. I'm pausing there just to do the maths to explain how the figures in this case work. The contractual quantity was 6,139 metric tons. If you divide 63,838 by the contractual quantity of 6,139, that gives you $10.399 per metric ton demurrage. Which explains the next sentence by letter G. There is a finding in the award that taking demurrage into account, the effective cost to SIAT was the equivalent of $126 per metric ton, compared with a contract price of $122, because you take 114, you add 2 for Venice to give you 116, then you add 10 for demurrage to give you 126. Mr. Justice Lloyd rejected the sale price to SIAT, and we see the reason why he did that on page 99. Beginning by letter C, he says, in most cases, such loss would be represented by the difference between the contract price and the resale price. But here, the resale price contained hidden elements. First, there was the option to take delivery in Venice. Arriving at the loss on resale, it's essential to compare like with like. Second, and much more important, there was the obligation on the part of SIAT to pay the demurrage. But for that obligation, the price would be $126. If the sellers had remained liable for demurrage, could they have recovered the demurrage as part of their loss on resale? So this is an example of a resale contract being rejected because it's not on like-for-like terms with the original contract. And that,
Was it, or because if you put it on like-for-like terms, it produces the same result?
Well, not exactly, and I'll come on to that in a moment. So there are a number of elements as to why this is an unacceptable. It's unacceptable to use the resale contract in this context. The first is that it's not like for like, and I say that that's consistent with Lord Toulson's preferred analysis of the default clause in Bundy and Adira. You may recall that I submitted that in relation to subclause A, Lord Toulson preferred the view that the substitute contract had to be like for like, and if it wasn't, it could be rejected.
Yes. You do have in this case slightly different wording, don't you? Market price or its equivalent.
It's not exactly the same, but it's the same, in my submission, it's the same thinking.
And you can take a resale price as the best evidence of the market price if you adjust it to make it like for like.
Yes, quite. And that comes on to the point about the other thing that's offensive about the attempt to use the SIAT price here of $116 per metric ton. So the problem is that under this version of the default clause, perhaps in contrast with the one we were looking at in the CELDA, the position was that you could not recover consequential losses. And so that meant that if the seller in this case had suffered a consequential loss of demurrage as a result of the non-acceptance of the goods, that demurrage as demurrage could not be claimed as consequential losses from the buyer. And that was because of the decision in Toprak and Phenagrain, which is discussed at the bottom of page 98 to top of page 99. So what Miss Justice Lloyd considered that the sellers were doing in this case was effectively trying to recover their irrecoverable demurrage by the back door. So what they had done is they had agreed a lower than market price with SIAT on terms that SIAT would pay the demurrage. So they got the benefit of that differential by getting a larger measure of damages under subclause A. And then, of course, they benefited again in the sense that having been made whole outside of the mechanism for demurrage, they weren't actually having to bear that cost and pay it to the ship owners. So this was an attempt, as it were, to get around the limitation on the recoverability of consequential losses by taking an artificially low resale contract price. The alternative, which Miss Justice Lloyd preferred, was to take the tribunal's finding that the market value, the fair market value of the cargo at La Spezia was $126. Now, that clearly is the same as the effective cost to SIAT once you add in the option and the demurrage, but it's not clear that they are necessarily linked in the sense that it's 126 because that's the effective cost. In fact, it's difficult to see how that could be the case because part of the effective cost to SIAT is the demurrage that they actually incurred at their actual discharge port of Venice, which would have been unknown at the time the goods were being sold. So in my submission, it's better to regard the $126 as an independent figure, which has been arrived at as the fair market value of the goods at La Spezia. And at La Spezia means, in this context, afloat and not landed or ex-warehouse, which is what I understood Mr. Cockerill to submit when he was addressing this authority. The result is a finding under subclause C that the market price on the date of default is $126 per metric ton, and Mr. Justice Lloyd clearly understood this to be a like-for-like value, i.e. a CIF La Spezia value, because of his reference to like with like in page 99 by between letters C and D, where he said it is essential to compare like with like. So he must have been treating this as a like-for-like value.
Sorry, where do you see that?
That's in, so by letter C, let's see, it begins in, it means the loss which is not too remote in law, and then if you go down 4 lines, in arriving at the loss on resale, it is essential to compare like with like.
Well, that's looking at the resale price as a...
Yes, well, he rejects the SIAT resale because it's not like with like, but it follows that he must be accepting the $126 on the basis that it is like with like, otherwise there would be an internal inconsistency.
And we can only get that from as it lay at La Spezia, I suppose. It's a new $126.
Yes, it's $126 as it lay at La Spezia.
And one finds that at G. Yeah.
Yes, quite, yes. And that's the point that my learned friend relies on. But in my submission, what this shows, and the discussion above, between E and F, about the significance of the liability for accrued demurrage, where he says he could understand if it was argued that the market price should take account of the liability for accrued demurrage. It's not entirely clear what he has in mind on the facts of that case, because the buyers are not going to be liable for demurrage, unless he's concerned that the ship owner might exercise a lien, the buyers have to discharge the lien to take the delivery or something of that nature. But that's, putting that on one side, the high-level point about these paragraphs is that Mr. Justice Lloyd is contemplating that the market price might have to take account of contingencies arising under the terms of the original sale contract. And in my submission, that, again, is consistent with my analysis, because what one is looking at is the value under the terms of the original sale contract, and one's looking for a proper substitute for that. So the proposition that I derive from the Euro is that it's authority that under subclauses A and C of the equivalent default clause, the market price of the goods had to be assessed on a like-with-like basis. That is to say, on the basis of the same terms as the unfulfilled contract. I was going to move away from...
I mean, one simply can't tell from this what the basis was for the tribunal's finding.
Of 126.
Of 126.
Well, no, they say it's a fair market value, and in a sense, it's remitted to them to determine the precise calculation. So by in G, the maximum entitlement is the difference between the contract and market price for the cargo as it lay at La Spezia. On the findings, I take this to be the difference between 126 and 132, but I leave that calculation to the Board of Appeal.
Well, that's a bit odd. What further calculation needs to be done? Unless,
yes. Well.
Unless the expression market value of $126 is in this report being used as a shorthand for about $126 because it had been calculated, or might have been calculated, on the basis that the resale price was the best evidence of the market price. The resale price as adjusted for differences in the contract.
Well, that is a possibility. We just can't say. In my submission, that would be, if that's what the Board of Appeal had done, that would have been slightly illogical because of the point I made about the demurrage
being at a different place.
Yes. So, although one
well, would it? I mean, if they've agreed to pay a price plus some demurrage, even though at that stage the demurrage isn't identifiable. It's perfectly reasonable, isn't it? To say,
well, if it's known at the time they agree the price, if they know what they're in for, but that doesn't seem entirely clear.
I mean, the resale contract was for 116 by the time it was a Venice discharge, plus whatever demurrage there happened to be.
Right.
And it would be open to a tribunal to find, but since those were the terms on which they were able to resell it, that is the best evidence of what the market price would have been for goods lying on the vessel.
It would be open, but given there's a contingent element, slightly odd way of doing it. There's a contingent element at the time of your performing the valuation and entering into the research.
Conversely, if the finding was of 126 as a market rate, I don't myself quite understand what there was to be remitted to the arbitrators for further calculation.
No. Well, it may be simply that because it's a factual question for the arbitrators and their decisions being set aside as arbitration law stood at that side, that was felt to be the appropriate way of dealing with it. Rather, it may be not sufficiently familiar with the procedures under the Act at that stage now to recall whether there was a power for the court to substitute its own decision in these circumstances. And even if there was, the court may have felt some diffidence about doing so.
Right, thank you.
The second of these authorities is the caloric, which is at page 100 of the authority file. That was a case of non-delivery rather than non-acceptance, so it's slightly different from our case, and it was non-delivery arising out of the political situation of Beirut in 1978. The cargo was a cargo of maize, and it was sold CIF Beirut at $119 a metric ton. In this case, discharge port demurrage was payable by the buyers under the sale contract at $5,000 per day, and we can see that from page 101 in the right-hand column. About halfway down the column, we see, on the other hand, Panyan were paying higher under the time charter at the rate of $6,000 a day, whereas demurrage under the sale contract, once it became payable, was only $5,000 a day. The vessel arrived off Beirut on the 2nd of October 1978. A few days before its arrival, the civil war in Lebanon deteriorated and the port was closed. On the 16th of October, the sellers ordered the vessel to sail to Italy, and on the 17th, they resold the maize, CIF Genoa, at $95 per metric ton. The sellers were found to have been in default by doing that, and the question was what damages the buyers were entitled to. In the last week of October, the buyers received an offer from Nadera to sell CIF by Beirut at $149 per metric ton. But the important point about this, and we can see these details on page 102. Sorry, maybe it isn't 102. Sorry, 101. The next paragraph down from the one we were looking at, the paragraph beginning, meanwhile, Lorico were pursuing their claim for damages. The important point about the substitute tender is that it was for shipment between the 25th of October and the 15th of November, and that it had an identical provision as to demurrage as the repudiated contract. You can see that from over the page. But if the goods were shipped between 25th of October and 15th of November, they were going to arrive much, much later than the original goods, which would, if the contract had been performed, waiting outside Beirut. And possibly they would arrive after the closure of the port had been lifted, because the port reopened on the 18th of December 1978. So depending where the goods were coming from, either there would have been no waiting or a much shorter period of waiting. The buyers didn't repurchase from Nadera, so this was a subclause C case and not a subclause A case. And subclause C here was in materially the same terms as the clause that we're concerned with. You can see that on page 102 in the left-hand column. The clause is clause 28, and we're concerned with the middle passage. In the event of default by either party entitling the other party to damages, such damages shall be based upon the actual estimated value of goods on the date of default, to be fixed by arbitration unless mutually agreed. The decision of the Board of Appeal that was under challenge is at the top of page 102 in the left-hand column, where they concluded at paragraph 76, subparagraph paragraph 11 of their award, skipping down to the last 4 lines, we are unable to give any precise estimate of the value of the goods on the 17th of October 1978 or thereabouts, but we find that such value would have been less than the contract price. And that was upheld by Mr. Justice Lloyd. There were, again, several stages to the argument. The submission that Mr. Justice Lloyd accepted was a submission of Mr. Johnson, which we have highlighted at page 102 in the right-hand column with the green sidelining. What the Board of Appeal had to do was to estimate the value of the goods where they lay, subject to all the terms and conditions of the contract. And that was accepted by Mr. Justice Lloyd in the next paragraph, the part with both of us at sidelined. These being the rival arguments, I say at once I prefer Mr. Johnson's approach. It seems to me that the goods, in the third sentence of the default clause 28, means, in this case, the goods which have been appropriated to the contract, in other words, the goods on board caloric. Pausing there, what in my submission he meant by this was that where the goods had been appropriated to the sale contract, in circumstances where the buyers had to pay discharge port on discharge port demurrage, and the circumstances meant that the actual goods would have been substantially delayed for discharge. The actual or estimated value of the goods on the date of default was not represented by the price under a contract for goods that were arriving much later, where the demurrage would be much lower. In other words, by insisting that the goods means the goods appropriated to the contract, Mr. Justice Lloyd was insisting that the comparison between the original contract and the notional substitute had to be conducted on a like-for-like basis, both as to its terms and also as to contingencies affecting the price payable under those terms. In my submission, we can see that this is what Mr. Justice Lloyd had in mind from the way that he suggested that the tribunal might have found out the value of the goods, which is on page 103 of the bundle in the left-hand column. The passage that we sideline in green, beginning, how then was the Board of Appeal to arrive at the value of the goods? So he gives two options. First of all, they might have made an estimate of when the goods would have been likely to have been landed. The amount of demurrage would by then have accrued. If they had then deducted demurrage and any other expenses of landing goods from their estimate of landed value, they would have arrived at the value of the goods on board at the date of default. That is fairly straightforward. The second option, alternatively, they might have taken the lowest price at which Messrs. Nadera were prepared to sell and make an appropriate adjustment for the fact that by the time the substitute goods arrived, the port would have been open, or at any rate the demurrage would have been very much less. So pausing there, what that option involves, I would suggest, is you assume that the Nadera price is $149 per metric ton with no demurrage. To value the original contract, you adjust the Nadera price down, because all other things being equal, a buyer will pay more for goods arriving later than goods which had already accrued substantial discharge port demurrage. And logically, the difference between the two ought to be the amount by which the demurrage payable under the original contract is greater than the demurrage payable under the Nadera substitute contract. And he says, on that basis, you can easily imagine that you could go down from 149 to less than the contract price of, I think it was 119. Yes. So that's the logic, and I say that that's consistent with Bungi and Nadera, because here the demurrage liability in the caloric is akin to the cancellation which would have taken place in Bungie and Viterra, it's taking that into account is all part of valuing what would actually have been performed if the contract hadn't been prematurely terminated. And so really this is all part of the same tort process.
Well, the second of those is, isn't it, fairly and squarely within the Bungie and Viterra test. If you take account of what Lord Sumption said at paragraph 28.4, that you have the latitude of taking a shipment on different terms and adjusting the different terms.
Quite. There's that aspect of Lord Sumption. There's also Lord Sumption at 21, where he talks about the fundamental exercise of valuation and what you're trying to do, that you're valuing what would actually have been performed if the contract had not been wrongfully brought to a premature end. But yes, it is an example of the flexibility that Lord Sumption recognises in the words actual or estimated value.
But the first of those does recognise that you can take as your starting point a sale once landed, but then you've got to adjust it backwards.
Yes, yes. Although I still have a slight logical difficulty with the element of hindsight in that approach, but yes, it certainly shows that that is a way of doing it. So in my submission, the caloric is authority for the proposition that the notional substitute must be, under subclause C, must be on the same terms as the original contract. Where contingencies affect the value of performance on the terms of the original contract, such as delay and discharge, the valuation of the notional substitute must take account of the same contingencies. Or to put it another way, what the tribunal and Miss Justice Lloyd were doing in the caloric was trying to prevent the buyers from obtaining superior benefits by relying on a contract, the Viterra contract price, which related to goods which had been shipped later and therefore would be exposed to less demurrage. That was all I was going to say about the authorities. That leaves really some sweeping up points. Firstly, there's the argument, the general proposition, that the judge's conclusions and the appeal board's conclusion is inconsistent with its own analysis. Now, firstly, my submission, these arguments won't take Sharp very far, because if one reaches a conclusion about what the correct construction of subclause C is, if there are any inconsistencies in other parts of the award, that doesn't really help the analysis. So these are really tail wagging the dog type points. But just to recap briefly, the first point relied on is the date of default, and I submitted on the first day of the hearing that wasn't a particularly helpful point, given that the only date of default that was before the board was the 2nd of February, and Sharp didn't propose any other, so one can't derive any assistance in relation to internal logic from the fact that that was the date which the board accepted. The second supposed inconsistency is the award of storage and legal costs to Viterra, but those were awarded for breach of the non-payment clause, because they were essentially consequences of the failure to cooperate in relation to release of the goods to Viterra. So that doesn't assist in relation to the analysis of the default clause. And the third point is the costs of discharge, the fact that that was to be repaid to Sharp. And in my submission, that's consistent with the logic that the benefit of being able to sell the goods landed and customs cleared was to be allocated to Viterra. And in any event, it's essentially treating Sharp like a bailee who's received goods under a contract which came to an end, and therefore is entitled to be remunerated for looking after the goods in the meantime.
These are the discharging costs.
Yes, the board awarded the discharging costs to be repaid to Sharp.
Yeah. So how does the bailee in that analysis?
Sorry, how does
the bailee analysis help
Well,
with
in a sense, it's a sort of restitutionary claim.
that? Well, I was going to ask you, it's a restitutionary claim for the benefit of having goods landed which, under the contract, they wouldn't have had to pay to have discharged.
Yeah.
Is that how you put it?
Yes, but none of this was really spelt out. And again, I mean,
No.
how come back to my main submission? How does this help once you've reached a view about the correct construction of the default clause, whether or not there are other parts of the award which are inconsistent, isn't really going to take matters much further forward.
Well, one could see applying at least the caloric logic that one way of assessing market would be to take the sale price in India once landed, but to deduct the discharging costs if you leave aside any question of demurrage and you leave aside any question of delay and storage.
Yes, of course, and of course one often sees that in expert evidence. There are various ways of getting to a CIF price at a particular place. You can work from an FOB price at the port of origin and add in freight, which is what the tribunal did, or particularly in the Chinese market, one often sees an analysis which says that the market is driven by the ex-warehouse price in China, which is a customs cleared price, and you work back from that to work out what the CIF price should be at any particular moment, because the demand is coming from the local domestic consumers. So yes, in principle, I quite accept that. There's more than one way to get that. The second issue is that question: did the tribunal do anything wrong by assessing a C&F price by reference to an FOB price plus freight? And again, I mean, firstly, there's nothing unusual about doing that, and secondly, the tribunal didn't have much choice, because that was the only evidence before them that went to the type of assessment that they concluded they should be performing. It was never submitted to them that if they were going to assess a C&F price, they had to do something else with the data that they were given. And so this is a classic example of a factual determination by the tribunal applying the correct legal test to the information before them, which cannot be challenged. At one stage, Sharp was applying to vary award number 4581A, but I understood that to have been abandoned in the course of oral argument, because I wasn't going to say anything more about that, although it was, of course, right that there simply isn't the material in the award. There aren't any factual findings which would enable this court to vary the award. And that, finally, brings me back to the question of law. And for that, we may need to put away the authorities bundle and have the law bundle. The award at tab 9 open at page 162. At page 162, we have the important part of paragraph 7.37 of the award, and that contains the appeal board's decision on the question of principle, which was in the middle of the page, just after the reference to Fungi and Adera. There's nothing in the judgment that, in the case of a straightforward default such as this, removes the requirement that damages are to be assessed based on market conditions for goods, the contract description and parity, on or about the date of default. So the decision of principle was that damages are to be assessed on market conditions for goods of the contract description and parity. What the tribunal thought was the contract description and parity is set out in the preceding paragraph on page 161, paragraph 7.36. apparent from 7.36 that the board were assessing damages by reference to the value of C&FO Mundra in bulk on the 2nd of February 2018 because they thought that was the contract description and parity at that date. So they say the contract which is the subject of this arbitration was not a contract for the sale of varying quantities of goods ex-warehouse into the domestic market in India over a lengthy period of time, but was for the sale of goods in bulk on the international market. And then in the last 4 lines they go on to say that that means that the market value has to be assessed by reference to the terms of the contract, i.e. for Canadian crimson lentils in bulk traded C&FO Mundra on the international market. If the appeal board was wrong to think that the contract description and parity as at the 2nd of February 2018 was C&FO, that was an error of law as to the nature of the contract at that date. And in my submission, this court cannot decide this appeal by reference to an error of law or an alleged error of law, which firstly doesn't arise out of a question which the tribunal was asked to determine, because it's a precondition to permission to appeal under section 69 subsection 3b that the question is one which the tribunal was asked to determine, and no one submitted in the arbitration that the original contract was no longer C&FO Mundra in bulk. It's also not the question for which permission to appeal to the High Court was granted. And with particular importance for this court, it's not the question of law which the first instance judge gave permission to be appealed on the basis that it satisfied the general importance test, there being a separate threshold for granting permission to appeal under section 69 from the first instance judge, that the question has to be one of general importance. And one can see that from numerous...
Or obviously wrong.
Sorry?
Or obviously wrong.
No, not at the second stage. It's or some.
I'm so sorry. The appeal to this court.
Yes.
Yes.
So permission by the
I'm with you. I'm with you.
Yes. But just to see what the judge thought the question was, or thought the question of law underlying the question was, we can see it perhaps most clearly from page 93. Paragraph 65 of the judgment, at the foot of page 93, at the heart of the dispute is the question of whether goods here means goods of the description sold on the terms on which they were sold, or goods at the market where those goods could have been sold. There are authoritative suggestions of both of the examples. That's one of many passages in the judgment which essentially capture the question of law in the same terms. Another one is paragraph 77 on page 95. 3 lines in, the particular issue which confronted the board in the present case did not feature in any of the cases relied on by Sharp. References to its valuation in a particular market or at a particular place obscure the fact that the real question in this case is not the physical location of the market, but rather the terms of sale on which the valuation should be based. So in my submission, it's simply not open to the court to proceed on the basis that the appeal board was wrong to think that the contract was still C&FO Mundra in bulk international sale. But if I'm wrong about that, one still has the problem. How is the court supposed to answer the actual question of law which has been put here? Or at least I would say, how is the court supposed to answer it adversely to me, which is the only thing I'm really concerned with. Just turning to that from the plain form at page 107, question of law is question 1.
I'm so sorry, which page are we on?
Page 107, tab 8 of the Corp.
Thank you.
Question 1. Even if one were to qualify that as where, in the circumstances of this case, goods sold to CNF free out are located at their discharge port, etc. If one was proceeding on the basis that one of the relevant circumstances of the case was that the contract had been varied in the terms of Addendum 1, so that it was now a sale on terms that the price was to be paid on instalments, there would only be in security for the first instalment, and so on. How does one sensibly answer whether it's A or B? Because the answer is neither, isn't it? And in that situation, there simply is not an answer to the question of law which is adverse to Viterra, and so the appeal must be dismissed, in my submission.
Well, that is quite a bold submission. One often gets cases where the question of law is framed, is the answer A or B, and if it's a question of law and the answer is neither, it's C, you give the answer C. You don't say, we threw up our hands and we're not going to tell you what the answer is. And we can't give effect to answer C if it's clear on the facts as found, if it's clear on the facts as found in the award.
Well, my lord, pragmatically, that's not a point that we took in relation to the question as we understood it to be, which is what is the correct interpretation of subclause C, and does it require the substitute to be on the same terms as the original contract? Although, as one can see from the judgment, even the judge felt considerable doubt as to whether there really was a question of law here and what exactly it was. But that is one thing, and permission having been granted, it would have been difficult for us to argue that we could go back on that and change the nature of the debate. And so we entered into that debate and we won at first instance. But this is quite a different debate if you build in the circumstances of the case and you build in a presumed variation of the contract so that it's no longer on CNF-FO terms, where the CNF-FO nature is built into the question, and the alternatives are between B, which is what the tribunal did to value CNF-FO, and A, which is on the basis that you value the goods where they are without any regard for the contract terms at all. So even if, as it were,
Is it? I'm not sure. If you manipulate the introduction to have words such as on the facts as found by the tribunal, by the board in this case, then the answer, if the variation is as we've been discussing, is A, isn't it? Subject to a small adjustment, namely it's at market value of goods at the discharge port, but on terms that risk passes immediately on contract, because you've got the slight wrinkle about the risk.
My lord, no, and this is my respectful submission, no, and this is the danger of this exercise, because the market value of goods at the discharge port is assuming that they're customs cleared.
Yes.
But under the terms of the contract, even as varied by Addendum 1, there was no variation to the fundamental provision of the original contract, which was the goods were not to be customs cleared by the sellers, that was the responsibility of the buyers. And so any customs clearance that happened outside of the Addendum 1 mechanism and the original contract. And so, couldn't take...
Leave aside the addenda, there was also the LOI, which formed part of the agreement between the parties, which did involve an agreement that they would be landed and customs cleared by the buyers, didn't it?
Well, my lord, I'm not sure that is right, and there is considerable uncertainty as to what was involved in the LOI. And that really illustrates the difficulty of interpreting this question of law against a wider canvas of facts than the question was interpreted at first instance, and indeed on the permission to appeal application. But anyway, you have my submission that the court shouldn't go down the path of considering the contract as valid for the reasons I
Yes.
previously gave. That that's a question of law which wasn't before the court.
Yes.
And that the court should proceed on the basis that the question of law was the question of law which the first instance judge was deciding. My lady, unless I can assist you further.
Thank you very much indeed, Mr. Collard. Maria?
May it please your ladyship. Ladyship will just. I propose to have three headings to my reply. The first one is the question of construction, which addresses overcompensation and windfall. The second one addresses Bungie and Viterra, the issue of replacement contract and future obligations. And the third one addresses other authorities. And then I'll address to the extent necessary the other smaller points that my learned friend has just made. Now, if your lordships and ladyship have available that table, one sheet of paper of, there was a table with some quotes at the back of it. I may have an extra copy if one is.
No, I think we've all got it.
Okay, I'm much obliged. So the first point is this. It's undeniable and indeed common ground that Viterra has been overcompensated by the tribunal's award.
I don't think that is common ground. This is based on figures which the tribunals
I'm
said
not
were
asking-
were not figures they could safely rely on as to the
Yes.
market price, as is where is X warehouse. So
I think
don't see
you're-
how it can be common ground.
I think your lordship is a bit ahead of me. Perhaps if you would just allow me to explain why it is common ground. Not those figures. Those figures are not common ground.
Right.
Those figures are not common ground. It is common ground that Viterra has been overcompensated. Now, before I have howls of protest, I will show you why it is common ground and can only be common ground. Firstly, if one looks at the core bundle, tab 9, page 164, this is the famous paragraph 7.41. And here there is an express finding that the goods were customs cleared, which is common ground. And the prices indicated by Commodities Control were for customs cleared goods on the domestic Indian market and did not reflect the value of the goods in the CNFO. Similarly, sellers' resale contract to Agricor did not reflect the true CNFO market. Now, the next sentence is what is crucial. These goods were customs cleared, and since the imposition of the tariffs on November 2017, the value of the customs cleared goods on the domestic market had undoubtedly increased. Now, so you have a finding there that and it's an obvious common sense consequence of the imposition of customs duties, that the value of the goods by the 2nd of February 2018, which is the date of default, which is the only date we're concerned with, the value of the goods had undoubtedly increased. So, because the compensation was not calculated on the basis of that increased value, there has been, on an objective basis, we'll put aside whether this is what the contract intended or not, but on an objective basis, an undeniable overcompensation, because they have been given damages which assumes a lower value for the goods, whereas the goods have undoubtedly increased in value in their hands. And this isn't just the award. I can see some quizzical looks, but I assure you, I'll explain that it is common ground. And no doubt, my learned friend, once after he's heard me, can stand up and complain if that's not the case. So you see that the tribunal has valued these goods that are in Viterra's hands on the 2nd of February 2018 with enhanced value, but it has ignored that enhanced value. Now, my learned friend says they're correct to do so. We'll get onto that. I'm simply looking now at the simple commercial question of, has there been overcompensation? Are they better off than they would have been had there been no breach? And in my submission, it's common ground the judge accepted, and indeed I say my learned friend accepts that they have. So I still see quizzical looks, so that's what the tribunal finds.
I think the quizzical looks are simply by the use of the term overcompensation, because that's a mixed question of mixed facts and law, isn't it?
Well, perhaps I should use it in common law terms.
I mean, we often have a concept of res inter alias acta, don't we, where undoubtedly parties have benefited in a way they would not otherwise have done so, but the court regards it as irrelevant to whether or not they have how you calculate loss and damage.
The essence of my submission is applying the overriding compensatory principle. So
that's what we need. I don't think anyone's in any doubt as to what the facts are by this stage. We know they were sold ex-warehouse. We know the price had gone up.
Right.
Is there any of that? None of that is.
Well, if none of that's in dispute, then all the only proposition that I'm trying to make is that there is nothing. If this is a question of construction, there is no authority binding on this court as to what.
The difficulty I have with your submission is that the increase in value,
yes,
as a result of the importation of tariffs, does fall to be taken into account if what one is concerned with is the contract as varied at the date of default. If, however, we're approaching this, as you are inviting us to approach it, on the basis of what is the general principle in relation to C&F free-out contracts at the moment of the date of default, then typically the goods will still be on the vessel, and one won't be in this realm.
Well, what we say is you have to apply the law to the facts of this case, and you have to apply subclause C to the facts of this case.
Yes.
And you have to look at what subclause C says.
Yes.
And subclause C says it's the actual or estimated value of the goods. And our simple proposition is the goods are the actual goods that are the subject matter of the contract, see the caloric, which on the 2nd of February 2018 were customs cleared and hence had an enhanced value.
Yes. And all I'm putting to you is that may be the consequence of the fact that this isn't a C&F contract at all anymore. And therefore, when you're applying Clause C, you're applying it to the actual bargain that the parties have lost at the date of default. None of that helps your generic arguments on the construction of subparagraph C, but it may help you if we are to look at this, despite the way the question of law is framed, on the facts of this case and on the basis that the contract had been varied.
The case had always been argued on the facts of this case.
Yes.
Sharp's position has always been, before the original tribunal and before the Board of Appeal, that it's the domestic prices in Mundra that should be used because the goods were in Mundra on the date of default, already customs cleared.
Yes.
the argument was very simple. All that the clause does is what the common law does, which is the overriding compensatory principle. What position would you have been in had the contract been performed? You being the innocent seller. You would have had the contract price. What position are you in? You have an asset in your hands that has an enhanced value. So what is your loss? It's the difference between what you would have got and what you do have. And that is where the tribunal fundamentally fell into error, because they said that we somehow have to recreate the contract that happened to bring the goods here, where that is absolutely unnecessary. And I'll show by reference both to Bungie and the source of this idea of a replacement contract. But the point I'm making, just for the court's reference, the acceptance of a windfall or overcompensation appears in the judgment at paragraphs 4 and 95. And in my learned friend's skeleton at paragraphs 5 and 81. I mean, in fact, he says there's a windfall here. We should get it. They shouldn't. And we had the debate. There is no windfall. It's just there's no loss, or there is reduced loss. And even if there had been windfall, as the Supreme Court has made clear, it's irrelevant in breach of contract claims, because breach of contract seeks to compensate for loss, not to force the guilty party to disgorge any gains. Now, there haven't been any.
The fact that there is an increase in value as a result of the imposition of an import tax is entirely irrelevant to the main question of law that we're being asked to decide. Leave aside any arguments about variation.
Yes.
If the date of default was taken as the initial point at which the contract was treated as at an end, and if it hadn't been, as it so happens, a day after the first of the imposition, suppose it had been before then,
Yes.
then you'd still be saying you must look at the price on the market as landed, as is, where is.
Yes.
So your argument doesn't depend in any sense on whether there is or isn't an increase in value as a result of the imposition of an import tariff, does it?
It's more of a forensic point that there is nothing, the point I was going to get onto is there's nothing in the language of Clause C that suggests that the parties intended, the innocent party, whether it be buyer or seller, to be overcompensated. And indeed, we say that my Lord Justice Popplewell was correct at first instance when he said in the Novison case that subclause C simply replicates the common law or the sex as codified in the Sale of Goods Act. And that's, I think, if I recall correctly, paragraphs 21 and 23 of Novison.
I'm just not very much helped by a windfall and overcompensation. We have to construe subclause C, and we have to look at what's required, and we have to do that, of course, in the light of the facts. But using terms of that kind, I can quite see why you want to do so, but it doesn't help me to reach a conclusion. So I think we ought to move on.
I'm much obliged. I would, with your ladyship's indulgence, just refer to one passage in Lord Toulson's judgment in Bungie and Viterra at tab 16. And it's paragraph 61. Just very briefly, my lady, and I shall move on from this. Page 191. And just under the letter J, his lordship had looked at different options, and he said the first construction would require the tribunal to adopt a blinkered approach to the facts, which would place the buyers financially in a far better position than if the breach had not occurred. This is most unlikely to have been the drafter's intention. And then he goes on, it is far more likely that the drafter had in mind the usual situation of non-delivery or non-acceptance of goods for which there is an available market. But I shall move on. The fundamental basis of Viterra's argument before the judge and this court is based upon a misreading of Bungie and Viterra. Sorry, Bungie and Nidera. The true proposition is as follows. A replacement contract is a mitigation measure that is only relevant when it is necessary to quantify loss from the non-performance of obligations remaining to be performed in the future.
Sorry, take this a bit more slowly.
Sorry.
Only relevant when it's necessary to quantify loss
from the non-performance of obligations remaining to be performed in the future after the premature termination of the contract as a result of the defaulting party's breach. That's where, and the only where, this replacement contract analysis comes into play. Now, first of all, take the court to the source of this analysis, and that's in the authority that I handed out on the beginning of the second day. And I did give to my Lord Justice Phillips clerk. It should be at tab 20. If it isn't, I do have an extra copy. Does your lordship have
It's
it?
Roper and Johnson, is it?
Roper and Johnson, yes. Now, I'd like to take this reasonably carefully because this is the source, and indeed, this is the authority indirectly cited, and I'll explain how, by Lord Sumption, not directly. So this was a non-delivery case. In April, the defendant had agreed, I'm looking at the head note, to buy 3,000 tons of coal to be taken in the months of May, June, July, and August. And what happened is the defendant refused to supply. On the 11th of June, the defendant definitively refused to deliver any coal. And on the 3rd of July, which the court will note is prior to the expiration of the contract, the plaintiffs brought an action for this breach and held that in the absence of evidence on the part of the defendant that the plaintiffs could have obtained a new contract on such terms as to mitigate their loss, the true measure was the sum of the differences between the contract price and the market price at the several periods of delivery, notwithstanding that the last period had not elapsed when the action was brought or when the cause was tried. Now, we'll unpack that because that doesn't really illustrate what the case decides. So if we could turn to page 174 of the report, at just above the first hole punch, there are the submissions of Mr. Herschel, Queen's Counsel, and Mr. Bayliss. in support of the rule. And Mr. Herschel says, having elected to treat the contract as an end by bringing their action on the 3rd of July, the damages are to be assessed with reference to the price at which the plaintiffs might have gone into the market on that day and obtained a contract for coal.
I'm so sorry, I haven't spotted where you are. Which page are we on?
Sorry, 174, my lord.
174, I'm sorry. Yes, I'm with you now.
174, just above the first hole punch.
Yeah.
And it's Mr. Herschel QC saying what they should have done is gone into the market on the 3rd of July whilst obligations remain to be performed and obtain a contract for coal of the particular description. Mr. Justice Brett says, what evidence was there or what probability that they could have obtained a contract for forward deliveries at the market price on that day? And then we turn to the next page, 175. Just very briefly, just below the first hole punch. This is a passage. I think this is, yes, we're still in Mr. Herschel's submissions. And he says at the very last sentence, contracts for forward delivery are by no means rare. Such contracts were made in, and he cites a couple of cases. So this is all to do with forward delivery. And in the judgments, Mr. Justice Keating, if I could start about 6 lines up from the bottom, he explains why this is a different case. The difficulty as to the measure of damages, or rather as to the principle on which the damages to be assessed, arises from the circumstance of the time of delivery of the coal extending over the whole of the month of August. Had the action been delayed until after the expiration of the time for the completion of the contract, we should have entertained but little doubt, for the case would then have been distinctly within the authority of Brown and Muller, and should have considered ourselves bound by that decision. And then he then explains, in Brown and Muller, where there were no future obligations remaining, all you do is you look at the end of each month and find the market price on those dates. And then starting with where I've got the red boxing, but here the breach occurred before the end of the period over which the contract extended. And the question is, what is the proper measure of damages in such a case? Mr. Herschel, in his very able argument, insisted that the true measure is the loss which had resulted to the plaintiffs at the time of such breach, and that the mode of ascertaining the amount of such loss is to inquire upon what terms the plaintiffs could have gone into the market and obtained a similar contract on that day. That, it is said, is the true and only measure of damages in such a case, and hence it is contended that it was incumbent on the plaintiffs here to give evidence of loss ascertained in that manner by showing what would be the difference between the contract price and the price at which they could have obtained a similar contract on the day of the breach, or that they were unable to obtain such a contract at all. Now, it appears to me that the plaintiffs cannot be called upon to give that evidence of that sort. And then the learned judge refers on page 177 to Frost and Knight and the decision of Chief Justice Coburn in that. And I go to page 178. Is it more helpful for the court, for me to allow the court to read it, or?
You'd like us just to read the red box part?
Yes, please.
Well, can I just understand? You're citing this for the proposition that in cases of anticipatory breach, it's the date, not of the anticipatory breach itself, but the date when performance was due, which is the date by reference to which you calculate damages. Is that the proposition?
Yes. Well, I'm actually citing this for where the idea of the replacement contract comes in. In what circumstance is it relevant to look at the terms of the replacement contract? And it's in situations where there are obligations yet to be performed and the contract has been prematurely terminated. Now, Bungie and Nidera makes that absolutely clear, but this is where it comes from. And what this case shows is even in those cases where you have a premature termination of the contract, even then, there is no necessary obligation to enter into a new contract. It's all a question of mitigation. So why am I citing this to the court? Because I am showing you why Lord Sumption and Lords Toulson, when I take you to them, say that this proposition that you tried to create a contract on the same terms applies where there is a premature termination of a contract. And we do not have a premature termination of a contract. We simply have a claim for price. And what this shows, this is a fortiori, because even where you do have a premature termination, you don't necessarily have to show a new contract, although you can simply work out when those installments would have fallen due and what the actual market price for each installment would have been. So all that I'm trying to show, and maybe I don't need to take it much further, is this whole proposition of replacement contracts is for forward contracts, premature termination.
Well, we've seen what was said in Bungie and Nidera, which is in the cases of anticipatory breach, it's the date for performance, not the date of breach, which is the date by reference to which you take the assessment of damages, but because of the obligation to mitigate, it will usually amount to the same thing. And then you can take us to Bungie and Nidera now and seek to persuade us that it's only in the context of that principle that they were dealing with notional substitute contracts at all.
Yes.
Is that?
Well, yes.
And I don't want to stop you showing us anything in this you feel we need to, but
well,
I speaking entirely for myself, I think I'm probably going to get more out of
Bungie
what Lord Sumption and Lord Toulson said the law was than where it may have come from in a judgment of Mr. Justice Keating.
Yes. I will just take you to, I won't take you to that passage, but I will take you to, there are passages of Mr. Justice Brett, which I have highlighted, which again make the same point. And Mr. Justice Grove on page 183 expressly uses about 1, 2, 3, 5 lines down, uses the word forward contract, which is what Mr. Justice Brett had used in argument. And then about 7 lines from the bottom, again, talks about forward contract. So this is all a discussion about replacing a prematurely terminated contract with another one for future performance. Now to Bungie and Nidera. Now, if your ladyship, lordships, have my table, at the back of that, there are some quotations which I've highlighted. I'm not going to, but that sets out in summary what we say, Bungie and Nidera, but
didn't you take us through all this quite carefully in your openings?
I thought I did, and I believe I did, but my learned friend seems to have read completely different passages and with missing out various crucial paragraphs, like paragraph 17 of Mr. Lord Sumption's judgment. So I think unless the court tells me it doesn't need it, I need to put into context what my learned friend has shown you.
Well, it's a question as to whether it's strictly speaking reply or,
Yes.
or repeat. But
Yes.
Anyway.
Well,
I was going to ask you about the line between reply and... but in any event, if you could just take us very quickly to what you're saying so we have your context. Because I
Yes.
think that we have all these points and we also have them, as you say, in writing. So just give us a couple of pointers.
yes. So I think if we go to tab 16,
Yes.
the crucial passages, they start at 177, page 177. I will be brief. Paragraph 12 starts with the words anticipatory breach of contract, and then 12 and 13 deals with that. Paragraph, what my learned friend didn't take you to is paragraph 16 and 17, and particularly,
But you did.
yes, I did. And
It's all marked up here.
I will simply make the point that 16H, what Lord Sumption is saying, is sections 50 and 51. It is not obvious how those sections apply when reason of an accepted renunciation and the contract has come to an end in advance of the contractual time for delivery.
Yes.
Right. So I think I had, and paragraph 17 is where he deals with that, and he, in my submission, draws an express distinction between breach and repudiatory breach of a present obligation and breach of an obligation in the future. And he expressly, in my submission, says that it's only in the latter case that you need to replace the contract. I won't say much more with regard to Lord Sumption, save that at paragraph 28, at the letter H and J, Lord Sumption makes it clear that what he's saying is obiter as regards the construction of the default clause. Page 182 H to J. And then with regard to the judgment of Lord Toulson, again, I think I have taken the court to it, but the paragraphs that my learned friend didn't address, which I had addressed, are paragraphs. I'm not sure whether you addressed 77 to 79, but I think I did address paragraph 78 in particular with the court. But the ones that he didn't address were paragraphs 83 to 85.
I certainly have those all very carefully marked up
Yes,
from your
so
previous
I don't need to take
submissions.
you. One very brief point, my learned friend said that the Eleanor D'Amico was inconsistent with what I argued. That's at tab 6. I just need to explain how that's not correct. I can do that by reference to the head note. Under a time charter dated December 14, 1979, the owners let their vessel Eleanor D'Amico to the charterers for a period of 3 years. That's 36 months. The penultimate full paragraph at the bottom of that column, the vessel was delivered on January 10th, 1972, and for a period of 14 months performed voyages both in the Italian and coastal trade and elsewhere. So, and then you can see from the end of the next paragraph that on March the 30th, the charterers treated the contract as an end. So, by my calculations, that leaves 22 months of unperformed obligations, 36 minus 14. So this was a case of repudiatory breach, leaving unperformed obligations for which the mitigation loss was going into the market and getting a new contract. So that doesn't show in any way that that is the mechanism that one uses, where all you have is non-payment of the price. I'll now move on to the other authorities. And again, I'll take this very shortly. My learned friend referred to the case of Macklin versus Newbury Sanitary Laundry, decision of Mr. Justice Horridge at tab 3. In my submission, that doesn't stand for any proposition, save that it's a decision on the evidence of what the market value of the horse that was not accepted was. Clearly, if you sell something with a warranty, it's worth more than if you sell it without warranty. So, given the horse was sold with a warranty to the defaulting buyer and then sold without a warranty, the buyer can say, well, you can't compare that because what you sold me was a more valuable thing. So that's Macklin. I'll now move on to what my learned friend dealt with today. Aria at tab 5, page 61. As I showed when I took the court through this, there was a non-delivery claim in that case as well. And that you see on the first column in the just below the first hole punch. And you see that at the bottom of that column where section 51(3) is specifically referred to. And you see that also in the held where section 51(3) is the first of the sections that is dealt with by the report. As far as what Lord Justice Diplock says on page 69, in my submission, it has to be read in the context of all the issues that were before the court, the primary one of which was the non-delivery case. But in any event, even if it did apply to quality, what is the principle that would tell you that it should be a different market for non-delivery or non-acceptance? If it applies to quality, and my learned friend says, Arbiter, that it applies
I suspect he would say, because in those circumstances, the buyer has actually accepted the goods in the domestic market at destination.
Yes. And
And
here,
that is why you're looking at the difference in quality on a warranty claim between the goods at the place he has accepted them, between the contract quality and the market price of goods at that market of the same quality. That's why he says the difference is. Non-acceptance is different because the goods aren't yet into the market at which they are accepted.
well, that's not our facts, but yes. But I think one can take it that Lord Justice Diplock did know that this was a non-delivery claim in there as well. And he would not have phrased himself in such a clear and broad way as he did if he wanted to confine that proposition just to quality claims. And there's no language of the type that my Lord Justice Popplewell suggests in that passage. I now move on to the Selda. Now, the highest point of my learned friend's argument on the Selda is, oh, this is all Arbiter. And that's how the judge dismissed the Selda as well.
Sorry, which tab are we at?
Oh, I apologise, my lady. Tab 11, page
Yes.
121.
Yes.
Well, I don't think that is quite the high point of it. Really, the high watermark of what seemed to be your submission was that here was a citation with approval of what Lord Justice Diplock had been saying in Aria,
Yes.
which, even if it was in the context in that case of a quality claim, is being approved in the context of this case, which isn't a warranty claim,
Yes.
it's a breach claim. And, I mean, have I fairly reflected?
Yes.
And one of the things he said was that what Lord Justice Hurst was doing for the purposes of addressing the Section 52 argument was simply recording the submission, not expressing a view as to whether that was or wasn't the right test in the case before him. It didn't matter because the point was foreclosed by the arbitrator's finding, and the arbitrator's finding would have been the same because importation into Turkey was not possible whether or not you applied a test of value in the market at Turkey as is where is, or notional substitute of a CNIF sale into Turkey. There wasn't a market.
We have two answers to that, my lord. Firstly, in my submission, just reading the passage on page 124, column 2, that's not the better reading of the passage. The better reading is he's accepting what Lord Justice Diplock says.
Yes.
If he had doubts about what Lord Justice Diplock said, or wasn't sure whether Lord Justice Diplock was correct, one would expect a unanimous Court of Appeal, because he is speaking for a unanimous Court of Appeal, to have put in a caveat to that event. But in any event, if we turn over to page 125, there is a reference to another dictum of Lord Justice Diplock at the bottom of page 124, and at the first hole punch on the left-hand column, the Court of Appeal says, Mr. Mayo's questioned the soundness of this dictum in the case of non-delivery as addressed by Section 651 of the Sale of Goods Act, and then thus necessarily its soundness is applied in Section 50. And the court says, that, however, is a point that is not necessary to resolve in the present, since the goods being by the contract for delivery CNF to Turkey, there was no available market for the goods in question. And the market that is not available is the Turkish market. We know that. So this is
marketing contracts for delivery C&F to Turkey.
Yes.
Which is entirely consistent with Mr. Collett's case.
But
We're looking at a market for a substitute C&F contract.
Well, it could be, or it's simply looking at the CNF because it's non-delivery. I now move on, my lord, to the euro metal. And that's at tab 7, page 90. I've taken the court through this. I'll just cite 2 passages. In my submission, this is direct authority for the proposition that under subclause C, you look at the market where the goods are on the date of default. Now, my learned friend on page 98 took you to the passage that's sidelined in green. And he took you through all these calculations. But in fact, the gravamen of Mr. Justice Lloyd's decision appears in that one sentence that I have put a red mark against, just above the letter H. Because he goes through all these calculations and then he says there is a further important finding that 126 represents the fair market value of the cargo at La Spezia on the date of default. And then again, he says that at the next page, just below the letter D, 2 lines down, that being so, can the sellers increase their recoverable loss by transferring the liability for demurrage to SEAT and reducing the price pro tanto? The answer must, I think, be no. The sellers can recover the difference between the contract and market price, but no more. And then he explains that he could understand an argument that the market price for this barley must take account of the liability for accrued demurrage, and he goes into the 55,000 figure. But he says no such argument was advanced by counsel for the sellers, no doubt because of the express finding that the market value of the barley, where it lay at La Spezia, was 126. It seems to me to follow that the difference between 126 and 132 represents the maximum loss recoverable under this contract. And then, equally importantly, just above the letter G, when he answers the question, he says, I would answer the question of law and the award as follows. Yes, the maximum entitlement of the sellers to damages is the difference between contract and market price for the cargo as it lay at La Spezia. That is the actual answer.
And in this case, it was still lying on the vessel.
Yes.
Yeah.
It could have been on the wharf.
And the market price could have been calculated by reference to a substitute sale of the cargo lying on board in exactly the same terms as the contract in that case. Not an as-is, where-is sale when landed.
Well, no, there's no requirement. There's no requirement in this judgment that that the market price has to be determined in any particular way.
No.
Right.
So I'm not sure I'm really understanding how it helps you very much. I know you put it in general terms. You have to look at where the goods are and the date of default. But what you are having to look at is what is the market value. And in this case, they hadn't been landed, they were on board, and a market value could be calculated by reference to a notional substitute contract.
Well, it's clear that there is nothing in this judgment that says if those goods had already been landed, any terms of these judgments would need to change. Because the answer is the maximum entitlement is the market price for the cargo as it lay at La Spezia.
Yes, but we don't.
Whether it's on board.
We don't know in this case how the tribunal arrived at that market price, and they could have arrived at it by saying that's the price of a notional substitute contract.
Well, they may have.
Well, if they have, how does this case help?
Well, it helps me because the question of law, I mean, here, the question of what is the question you have to ask? The question you have to ask is what is the value of these goods where they are? That is not the question that this tribunal asked. These goods were at La Spezia, whether they were on a ship, off a ship, wherever, they were in La Spezia. The question that the tribunal asked itself was the correct question. How much are these goods where they are valued? That is precisely what the tribunal in our case refused to do. Because they said, oh no, we have to value something on the international market, CNFO, we have to replicate the contract. They expressly refused to take into account that the value of the goods had increased because that increase wasn't factored into their theoretical constructed value. So,
what was the basis on which you were entitled to the discharging costs in this case?
Because they were, because the goods ended up in the hands of the sellers, they got the benefit of that discharge.
So it's a restitutionary claim?
Well, I'm not quite sure how it was put, but it's...
how should it have been put? Never mind how it was put. What is the legal basis for an entitlement on the part of your clients to those discharging costs?
Well, the legal basis, I'm not sure how it was argued before the tribunal, is simply one of quantifying the loss that is payable to Viterra. Their loss has been reduced because, whereas all they would have had was the price, they now have goods that have been discharged for them. But I'm not,
Hold on a moment. That means, doesn't that rather undermine your basic proposition that all you have to look at is a sale of the goods in the particular circumstances where they are and they have been landed? Why do you have to make any adjustment?
Well, my lord, I'm not going to here argue about the tail wagging the dog here. The tribunal awarded what they awarded. The question for this court is what is the correct question of law, and if the tribunal incorrectly awarded those, then maybe a cross appeal should have been made on that.
But is your case that it ought to be made without any adjustment for discharging costs?
I haven't thought through how that affects the calculation of damages. So I'm unable to commit to that. But what I say is, as a question of law, what does subclause C require? Subclause C requires the determination of the difference between the price that would have been paid to the sellers minus the value of the asset that they have. Now, it may be, again, I've not thought through it, it may be that if there is some payment back, and it's a notional payment because it's offset, then that may come back in when you do the calculation of the damages. But
Comes back in because under subparagraph C, it's all part of the market value.
well, you will get.
How does it come back in?
Well, I'm saying it may do. I haven't thought it through, so I'm unable to commit. But that doesn't really, if that was incorrectly paid to us, and it's never been argued that it was. But if it was, then it should have been subject to a cross appeal. But and I'm not saying it was. I just haven't on my feet. I'm not in a position to be able to say one way or the other. But I can't, with respect, see how that affects the answer to the question of law that is before this court.
The tribunal seems to have effectively ignored the fact that the goods were discharged and were sitting in a warehouse on the other side of the customs. Have they not?
Yes, save when it suited them, because I will go to this inconsistency point. That again, I accept. Ultimately, the question of law is as it is. So they accepted all this thing, but they ignored it for the purposes of valuation, yes.
Yes. Well, it's almost as though they took the view that that process was without prejudice to the claim for damages.
Yes, but that's inconsistent.
You say it wasn't.
Inconsistent with their finding.
It was done by
of the
agreement.
default.
It was done by agreement.
Yes.
So if it was done by agreement, why do you not say that you have to look at what that agreement was to see what the ultimate contract was?
Well, I mean, your lordship's hands. The case was argued as it was, not by me or any lawyer.
Well, it's still
before
being
the
argued
tribunal.
by you on the basis of CNF contract.
It is, as I understand your position, it is you don't primarily rely on a variation to the contract, but if you're wrong on what you're currently arguing,
Yes.
then you adopt that as the relevant
Yes.
analysis. Is that
Yes.
fair? That was how I'd understood
Yes.
your position ultimately, if perhaps a little reluctantly,
Yes.
at the last hearing.
Yes. We are confident that when your lordships and ladyship read paragraph 17 and paragraphs 83 to 85 of the Bungie and Nidera judgment, you will see that this whole replacement contract analysis has no place in this in the facts of this case.
When I was looking at market value of goods, in relation to freely tradable commodities, it's almost the same thing as replacement contract.
Yes.
Replacement contracts are going to be the market value.
Yeah.
So it sounds like the only issue in relation to the anticipatory breach is that when you have anticipatory breach, you can't take the immediate market value because you're not looking at the right date. So that's where you get into the question of going out and getting a replacement contract as mitigation. It doesn't seem to me it amounts to any more than that.
That's, with respect, we would agree. And the only reason we're before you, we wouldn't be before you, the only reason we are is because of the imposition of duty before the default date. And we say the tribunal, having chosen the default date that it did, could have chosen a different one, but it chose the default date that it did.
But if you had argued firmly and distinctly that the parties had varied their contract by agreement so that the goods moved by agreement into a warehouse, still belonging to the sellers, and were then sold, that the contract was ultimately one where they were discharged to you from the warehouse, would have been X warehouse, then there'd have been no doubt that the C, category C, would have been in your favour.
Yes. But
But that's where it's gone wrong, isn't it?
well, these are trade arbitrations, my lord, and they're argued by trade representatives, and it's perhaps didn't have quite the.
I'm not expressing blame now, just trying to work with.
Yes.
You were saying to us what happened here.
But-
See, what happened here is that, and what we have to bear in mind is it looks as though the tribunal had presented to them an agreed position on what the nature of the contract was, and they sought, doing the best they could, to replicate that when assessing damages.
Well, one needs to be careful here, because the Sharp's position had always been that you take the domestic market at Mundra on the date of default, and all their evidence was for that valuation. They made exactly the points that I'm making to you. Is these goods are in Mundra, they have the value of them. In fact, attempts were made to try to get disclosure of how much Agricor, Viterra's related company to whom it had sold the goods, had sold them on into the market, and that wasn't possible because they're not a party to the arbitration. But it's if one looks at the award, it was very clear what we were saying was the correct valuation method. It was very clear that we were saying it's the value of the goods left in Viterra's hands on the 2nd of February 2018. So, one quick, let me just see if there's anything else on that. Oh, there was a question about, there was a debate my Lord Justice Popplewell had with my learned friend about why it was being remitted at the letter G. I think what my learned friend didn't read is, but I leave the calculation of the precise amount together with interest to the Board of Appeal unless this can be agreed by the parties. Now, by my calculations, there was a 4.5-year delay between this judgment and the original repudiation, which was in 28th of June 76. Some of us who are old enough will remember that interest rates were very volatile and high in the late 70s. And it may well be that Mr. Justice Lloyd, as he then was, felt that that wasn't a calculation for him. Caloric. Just the one proposition that my learned friend hasn't addressed and can't get around is the holding that at page, it's in the head note, the first holding in the head note, the words "the goods" in clause 28 meant the goods which had been appropriated to the contract. And if one reads the passage at page 102, one can see that in the red highlighted sections, Mr. Justice Lloyd says, to me, the goods in the third sentence means, in this case, the goods that had been appropriated to the contract. In other words, the goods on board the caloric. And he repeats that again at the bottom of that paragraph. And there's no reason why it should mean that in a non-delivery case and not in a non-acceptance case. That's what the goods mean. And finally, oh, yes. If we could go briefly to the award, there was a question of whether there was any alternative date proposed for the date of default. Perhaps we could go to page 159, tab 9. So we've got so you see that the buyers did not accept the seller's declaration of default. Second, the goods were not available to the sellers until the 2nd of February, which was the date ultimately chosen, whilst the seller's declaration of default was the 9th of November. Is the apparent date of default, it is clearly impossible for sellers to resell the goods and thus establish damages in accordance with the default clause until they were able to obtain possession of the goods. But that's, I mean, it's a forensic point perhaps, but that's a recognition by the tribunal, is that it's the ability to sell the goods, on-sell the goods, that gives you the valuation of those goods. And at 7:30, page 160, just 5 lines up, it therefore follows, and we find that sellers, having fulfilled their obligations under the contract to ship the goods in accordance with its terms and to present contractual documents for payment, were not in default. The date of default was not therefore 18th of December 2017. Sorry, yeah, that isn't relevant. If I may take instructions, my lady, and I think we may be done. Unless I can assist your ladyship further, those are my submissions.
Thank you very much indeed. There's just one thing, I don't know whether Mr. Collett might want to make some comment on Roper. I don't think he had an opportunity.
Yeah, I can do that very briefly. Roper essentially is authority for the proposition that Lord Sumption summarised in paragraph 17 of the judgment in Bungie and Dera, the point about the date of assessment, and it also stands for the proposition that it's on the defendant to allege a failure to mitigate. My learned friend seemed to switch arguments. So previously, what he said about Bungie and Dera was that it was all about anticipatory breach and not actual breach. What he seemed to be moving towards, as he looked at it again today, was to contrast the situation where you have a contract for performance at a particular moment, where that performance does not occur, and a contract for performance over a period of time, where performance does not occur and termination occurs for the remainder of the balance of the time to pay. And those are two different points. They're not the same analytically at all. But neither of them does Bungie and Dera help him, in short. And so I'm not sure. And that is a point that I did address in my submission on Bungie and Dera, so I don't need to repeat that. But just to highlight that there was a movement away from the earlier arguments.
Thank you. I think I was just looking for your help in relation to Roper, but that's fine. Thank you very much indeed, and thank you to both of you and to those behind you who've no doubt done a great deal of work also. As you'll be perfectly aware, well, first of all, we're not going to give judgment today, which you'll probably be not very surprised at. And as you'll be perfectly aware, judgments these days are handed down mostly electronically here. We won't expect you to come back. We'll expect you, in fact, to be able to deal with consequential matters by agreeing them. And if you can't, then very short written submissions is the way forwards, as you'll also appreciate. We will also obviously circulate a draft or drafts, and as usual, please don't re-argue the case as a result. I ought to also remind you about the embargo and how important it is that those drafts are only circulated to people who are on the list of potential recipients, and that's already been dealt with through our clerks, and so you'll be aware of that. Be terribly careful about that. And so I don't think there's anything other to say than I wish you a very happy Christmas, and I'm very grateful to all of you for your argument and for all your hard work. Thank you.
All right.